Hey, welcome everyone. This is Rebecca Smith-Aldridge, the Executive Director of the Mid-Hudson Library System and the co-author, along with Jerry Nichols, of the Handbook for Library Trustees of New York State. So we welcome you to introduce yourself in the chat. If you've been here before, you know the drill, but go ahead and share your name, your library, and how long you've served on the board. And I'll point out that also in the chat box, if you're having any technical issues, you can reach out to Laura Chrissy, who's here from the Mid-Hudson Library System staff. She's our Library Sustainability Coordinator and is very generously here to help us with any tech support issues you may have while we're on the webinar here today. I'll also point out a couple of other familiar faces for you. Online today is also Brian Hildreth, Executive Director of the Southern Tier Library System, and Ron Kirsup, Executive Director of the OWL Library System, which you might formerly have known as the Pioneer Library System based in Canandaigua. Brian and Ron are going to help moderate questions after Kirsten O'Neill has a chance to present some basics on open meetings law. So that's just a little reminder to you. We love it when you're chatting in the chat box, but if you've got direct questions you want to make sure Kirsten sees tonight, make sure you use the Q&A feature of the software to put those questions in so we don't miss them in the chat box. There's a lot of people online tonight, and we certainly don't want to miss anything you were hoping gets covered while we're together here. So before we go much further, as always, we want to thank our partners that make this possible, starting with the Public Library System Directors Organization, of whom this project lives within, but then, of course, our promotional partners from the New York State Library to the New York Library Association, and two very special sections of the New York Library Association, the Public Library section and the Library Trustee Association section. We know it's a membership renewal season, so when you're renewing your NYLA membership, don't forget to pick your sections of PLS and LTA. So those of you who've been here before, you know the plan. We want to make sure you get a solid introduction to the topic. And tonight's topic is open meetings law of New York State. And we have a special guest speaker to help us with this, Kirsten O'Neill, who I'm going to introduce in a moment. And then we'll address some of the questions that already came in, as well as opening up for the questions that the audience here live has for us. And we'll do our best to get as many of them answered as possible while we're online together today. But as always, if we don't get to it, you can come to the after party recording at the end of the season where we'll tackle everything else. So as this is a book club, we'd asked you to read a chapter in the handbook. So we'll point out that the open meetings law was recently amended, and that's part of what Kirsten's going to be talking about here tonight. But all the info in the handbook, even though it's from 2018, is still solid. Nothing's out of date in the handbook. There's just some new information to augment that, which will certainly feature in the new edition of the handbook coming out later this year. So Kirsten's going to update us on what's recently changed that you're going to want to be aware of. So you'll want to stay tuned to the end. So I'll just want to make 2 or 3 points here before I introduce Kirsten. But, this is actually our 3rd year of the Trustee Handbook Book Club. And I'll just point out that we routinely stress the point that public trust sits at the core of democracy. And we talk about trust and your role as trustees all the time. And that trust is part of why people believe in libraries and invest in libraries and respect the work that we do, because we're transparent and accountable in how we use taxpayer dollars to produce library services for the people of New York. And the open meetings law provides a very large framework to build trust in our communities by doing our work in the full view of the public. So as we think about that work, that trust is built with consistency. Open meetings law is there to help us be consistent in our transparency and accountability with the public. So adherence to this law, I think, is a very high calling. Of course, it's the law, you need to follow it, but understanding the ins and outs of it is every trustee's responsibility. All types of libraries fall under open meetings law. And I'm going to say that one more time so Kirsten doesn't get that question and you're paying attention the whole time this evening. All types of libraries, including association libraries, fall under open meetings law. There's one little difference, which is the committees of association libraries do not fall under it unless you're in a population of over 1 million. So for most of you on the line tonight, maybe not you, but I think it's an important distinction to understand association libraries do fall under open meetings law. So there's not 2 sets of rules here. We're all listening to the same message here from Kirsten. So I'm sure you'd prefer to hear from Kirsten rather than me here tonight. So I'm going to introduce Kirsten O'Neill, Esquire, the Assistant Director of the Committee on Open Government, who is so generously here to share her time and energy with us here tonight. And so it's my honor to introduce Kirsten. Kirsten received her law degree from the University of Buffalo And as assistant director of the committee, she provides legal advice regarding application of the New York State Freedom of Information, open meetings, and the personal privacy protection law. So all things near and dear to the hearts of library people. And we know she's addressed numerous organizations because she's been here at Mid-Hudson at least twice, and I know Ron's had her there too. And you might recognize her name because she's written literally hundreds of advisory opinions on behalf of the Committee on Open Government. So a lot of what we know in the field about open meetings law has been thanks to Kirsten's work to interpret the law on our behalf. So I'll just point out that she doesn't just speak with libraries. She speaks with government representatives of all types, advocacy organizations, and media representatives to better understand these laws that they used to be called sunshine laws. I don't know if they still are, but I'll just say, I really want to thank Kirsten for being here. I know maybe she thinks it's part of her job, but not everyone does their job as well as she does. And we're just very lucky and honored to have her here tonight. So Kirsten, without further ado, I'll turn things over to you.
Excuse me. Thank you, Rebecca. I really appreciate the invitation, and I do enjoy being here with all of you and trying to help everybody understand their rights and obligations under the open meetings law. So we'll get started tonight. Rebecca asked me, I have the PowerPoint set up. At some point, I'm going to flip it a little bit because I'm going to start, instead of focusing on the video conferencing at the beginning, I'm going to do the overview first. So at some point, I'll just be slightly distracted by flipping it, but I'll get started. And let's see. So up on the screen right now, you'll see my contact information. That's my email address. If you have questions at the end of the program, I'm going to provide you with a second email address that goes to everybody in the office at the Committee on Open Government. There are 4 attorneys that work for the committee, our executive director, myself, and 2 senior level attorneys are available to answer any questions you have about either the Freedom of Information law, if you are a public library, or the open meetings law for all. As Rebecca said, all types of libraries are subject to the open meetings law. Also on our screen is our phone number, 518-474-2518. Again, if you call and ask to speak to an attorney, it doesn't have to be me. Sometimes if you just ask to speak to an attorney, you're going to get an answer a little bit more quickly than if you ask to speak with me specifically. But we all try to get back to return our phone calls and answer emails as quickly as possible. Our website is www.opengovernment.ny.gov, which changed a couple of years ago. It used to be based on the Department of State website, but now we have our own URL. So it's www.opengovernment.ny.gov. The open meetings law is codified in New York State Public Officers Law. We always maintain an up-to-date version of the statute of both the open meetings law and the Freedom of Information law on our website, on the Committee on Open Government's website. Anytime there is an update to the statute, we try to get that information right up on the website so that when you go to our website, you are looking at the most up-to-date version of the statute. The legislative intent of the New York State Open Meetings Law was that it is essential that public business be performed in an open and public manner, and that citizens be fully aware of and be able to observe the performance of public officials. Citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. So here I'm just going to take a second and kind of skim through here. Oh, let's see. I shouldn't mess with things. I should just do it the old-fashioned way and skim through individually. Yeah. Anyway. So the New York State Open Meetings Law governs meetings of public bodies. And that term has an unfortunately very lengthy definition, and its length, it became this long a couple of years ago when the legislature and the governor's office, by passing the legislation, they were attempting to codify advice that we've been offering, the Committee on Open Government has been offering for many years, and judicial precedent relating to not just governing bodies of towns and villages and cities and library boards of trustees, but also other entities which serve a necessary function in government's decision-making process. So the definition includes any entity for which a quorum is required in order to conduct public business, which consists of 2 or more members performing a governmental function for the state or agency or department thereof, or for a public corporation, or any committee or subcommittee or other similar body consisting of members of the larger public body. So I'm going to take a little break in the definition there. So essentially here, for your purposes, the Library Board of Trustees is a public body as defined by the Open Meetings Law, but only library boards of trustees for public libraries are meet the definition under the New York State Open Meetings Law. But those, so as Rebecca said, don't tune out association libraries, because there's a provision of New York State education law that requires all libraries, including association and free libraries, to comply with the Open Meetings Law. So while the Board of Trustees for the public library are the only ones that meet the statutory definition under the Open Meetings Law, New York State education law says we want all libraries to comply with the Open Meetings Law. So all library boards of trustees need to comply with this statute. However, again, as repeating what Rebecca said, is that because public libraries are the only entities for which their governing bodies meet the statutory definition under the Open Meetings Law, that's the only situation in which committees and subcommittees of the Board of Trustees must also comply with the Open Meetings Law. For association and free libraries, just the Library Board of Trustees need to comply with the Open Meetings Law, except in cities of the population of 1 million or more, which generally is just New York City. Definition was expanded to include any entity that is created or appointed to perform a necessary function in the decision-making process for which a quorum is required in order to conduct public business, which consists of 2 or more members. And then the law goes on to say that a necessary function in the decision-making process shall not include the provision of recommendations or guidance, which is purely advisory and which does not require further action by the state or agency. So again, very wordy, very lengthy, gets a little bit confusing. But luckily for you, a lot of the issues that this revised definition were intended to address don't come up in the library settings. So if you have any sort of advisory bodies, if you have any voluntary bodies that are created to serve the library, let us know, reach out to us, and we'll try to help you work through it to determine whether those voluntary entities are subject to the Open Meetings Law. Definition of quorum. So I refer to, in the definition of public body, there's a reference to when a quorum is required. And general construction law, New York State general construction law, defines quorum. And it states whenever 3 or more public officers are given any power or authority, or 3 or more persons are charged with any public duty to be performed or exercised by them jointly or as a board or similar body, a majority of the whole number of those persons or officers gathered together in the presence of each other or through the use of video conferencing shall constitute a quorum. And not less than a majority of the whole number may perform and exercise such power, authority, or duty. For purposes of this definition, the words whole number means the total number there would be if there was no vacancies on the board and were none of the persons or officers disqualified from acting. So let's just use a practical example. Let's say you have a 7-member board of library trustees. A quorum is always going to be 4, regardless of how many people show up to the meeting, regardless of how many people are currently serving on the board. If at full strength, your board is supposed to have 7 members, the quorum is always going to be 4, regardless of how many people are actually there. That's how you determine quorum. How many people are supposed to be on the board if there was no absences or vacancies or if no one was disqualified. So here I have a section that distinguishes between who counts for a quorum when video conferencing is being used. And we will talk about this a little bit more towards the end of the program. But in short, members who are participating from open physical locations that have been properly noticed and are open to in-person public attendance do count towards a quorum, and those people can fully participate and vote. Members who are video conferencing from a remote location that's not open to in-person public attendance do not count towards a quorum. If a quorum has otherwise been met, those individuals that are participating from what I'm going to refer to later as extraordinary circumstances video conferencing can fully participate and vote if a quorum has otherwise been met. The Open Meetings Law defines meeting as the official convening of a public body for the purpose of conducting public business, including the use of video conferencing for attendance and participation by members of the public body. There is no authority for a public body to take action outside of a meeting. In order to determine whether you are having a meeting that is subject to the Open Meetings Law, you ask, is there a quorum present? Are you there to discuss public business? If the answer to those questions are yes, you're having a meeting regardless of the intent or lack of intent to take action or how you characterize the meeting. There's no legal distinction between workshops and work sessions and agenda sessions or regular meetings, informal gatherings, pre-board meetings. Call it what you will, but if your quorum of your library board has gathered for the purpose of discussing public business, it is a meeting subject to the Open Meetings Law. There are other types of gatherings that may not trigger the requirements of the Open Meetings Law. For example, site visits. I'm not sure how frequently this would come up in the library world, but there are circumstances where a board needs to go visit a piece of property or a facility that that maybe a municipality, for example, owns or is thinking of purchasing or selling. They want to go on a site visit, and basically they are going almost like on a tour where someone else is taking them around and showing them perhaps the pros and cons of a particular property, things of that nature. As long as the board refrains from engaging with each other and discussing the pros and cons of the property, and they're just receiving information, listening to the presentation, then it does not trigger the Open Meetings Law. Retreats or educational seminars where the purpose of these gatherings is to learn, maybe learn team building skills, maybe to learn about the Open Meetings Law or the Freedom of Information Law or other state statutes that govern the conduct of libraries. Maybe you're going to, to some sort of training program such as that. If that's the case, often those types of gatherings are not going to trigger the requirements of the Open Meetings Law, because even if you have a quorum present in the room, the likelihood is you're not there for the purpose of discussing public business. You're not there for the purpose of discussing your library business. Something that sometimes comes up is if you have committee meetings. Again, this probably is not as common in the library world as it might be for example, at the county level. This comes up fairly frequently. If you have a 9-member board and the board is broken up into several committees, and all of those committees are required to comply with the Open Meetings Law. If you don't serve on a particular committee, but you would like to attend that meeting anyway, you're free to do so. You're free to attend a committee meeting that you don't serve on. If you're on, if you are one of the board members, you just have to refrain from engaging in discussion with the people who do serve on the committee, so it does not appear as if you are acting in your official capacity. And of course, there's social gatherings. If you, as a library, want to have some sort of holiday get together, a summer barbecue, something like that, there's nothing preventing you from doing that. There's nothing preventing a quorum of a public body, such as a library board of trustees, to gather in a social setting for any reason. Again, as long as they refrain from discussing public business at those social gatherings. Definition of meetings requires physical presence at one or more physical locations, or, again, as I'll talk about later, video conferencing that is permitted if it is authorized pursuant to section 103A of the Open Meetings Law under extraordinary circumstances. A public body cannot conduct a meeting via email. Doesn't mean that members of the public body cannot share information via email. You can email each other with interesting articles, data, information about what other library boards might be doing, suggestions for improvement. All of that information, there's nothing wrong with sharing that type of information via email. What you want to refrain from doing is engaging in substantial deliberations that are not repeated during the open meeting. And certainly there's no authorization to vote via telephone call or email. Rebecca, do you want me to take a little break here to see if we have questions?
Hey, Kristen, we'll save the questions till you're done with your content. We're tracking them as they come in.
Okay. Notice of a meeting, the date must include the date, time, and location. And if appropriate, instructions for virtual attendance must be included in the notice. Must be given prior to every meeting to the media. Doesn't mean you need to purchase a legal notice. It just means that media needs to be notified that the meeting is taking place. Must be placed in a designated physical location. And if the library, the Board of Trustees has an active website, the notice must be posted on that website. In terms of timing, notice must be provided at least 72 hours prior to a meeting that is scheduled at least 1 week in advance. For meetings that are held on short notice, notice must be given to the extent practicable at a reasonable time prior to the meeting. The Open Meetings Law itself is silent as to when a public body is allowed to have meetings on short notice, but the courts have weighed in. So the Open Meetings Law just says, yep, you can have meetings on short notice too, and you have to give notice, notice must be given to the extent practicable at a reasonable time prior to the meeting. But it doesn't say when you're allowed to have these meetings on short notice. And that's when the courts have filled in the gap. The courts have suggested that the propriety of scheduling a meeting less than a week in advance and providing less than 72 hours notice is dependent upon the actual need to do so. I think a body should ask themselves, would any harm be caused by us waiting to our next regularly scheduled meeting, or at a minimum, providing a full 72 hours notice and scheduling the meeting a week in advance? Would any harm be caused by waiting? And if the answer to that is no, no harm would be caused, then that's what you should do as a public body. You should wait and give that full amount of notice. Here we're going to discuss some amendments to the Open Meetings Law are going to be sort of filtered in. So this is a combination of update and overview, because many of the basic provisions of the Open Meetings Law have been slightly amended in the past couple of years. Not huge overhauls, but slight amendments to be aware of. In October of 2021, Governor Hochul signed into law Chapter 481 of the laws of 2021, which amends Section 103E of the Open Meetings Law to require that records that are scheduled to be discussed at an open meeting be made available to the extent practicable upon request and posted online at least 24 hours before the meeting. As a reminder, there's been a provision of the open meetings law requiring records scheduled to be discussed to be made available. But previous to this, prior to October of 2021, the obligation to make records available to the public was upon request prior to or at the meeting. It just said prior to or at the meeting, and to post the records on the agency or public body website prior to the meeting. That's been in effect since February of 2012. This amendment that requires that the records be made available at least 24 hours before the meeting, that is the only change that was made to this provision. So that's the amendment. The 24-hour minimum time frame is the amendment. The obligation to make records available, records scheduled to be discussed at an open meeting, that's been in effect since February of 2012. What does this include? It includes any proposed resolutions, laws, rules, regulations, policies, or any proposed amendments to those items. It applies to any records or portions of records that would be public under FOIL and that are scheduled to be discussed during an open meeting. It does not apply to records that are scheduled to be discussed during executive session. So again, must be made available upon request at least 24 hours prior to the meeting and must be available online at least 24 hours prior to the meeting. If the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. I know libraries are pretty high-tech these days, so I'm going to guess that most of you have a regularly and routinely updated website and utilize a high-speed internet connection. Minutes. Minutes of meetings must include a record or summary of all motions, proposals, resolutions, and any other matter formally voted upon. For executive session, you're only required to prepare separate minutes or specific minutes of an executive session if action is taken in an executive session. So if a public body merely enters into executive session to deliberate, but then exits executive session to vote, then you don't need to prepare specific minutes of the executive session because no action was taken in executive session. But if you do vote in executive session, you need to make sure that you comply with the time frame for preparing minutes of an executive session, which is 1 week. It's 2 weeks for a regular meeting, 2 weeks for open session, 1 week for executive session. Once those minutes have been prepared within the appropriate timeframes, they must be made available upon request. It does not matter whether those minutes are unapproved or in draft form. They still must be provided if someone asks for them. In addition, in November of 2021, Governor Hochul signed into law Chapter 587 of the laws of 2021, which amended the open meeting law to require that agencies that maintain a website and use a high-speed internet connection must post their meeting minutes on their website within 2 weeks of the date of the meeting or 1 week of an executive session. The law goes on to state that for purposes of the posting requirement, so just for purposes of the posting requirement, unabridged video or audio recordings or unabridged written transcripts may be deemed to be meeting minutes. So I just want to clarify here that if you record your meetings and have unabridged video recordings or unabridged audio recordings or unabridged transcripts, this does not relieve you of the obligation to prepare meeting minutes. You still need to prepare meeting minutes. All this does is relieve a public body of the obligation to post its meeting minutes if instead it would prefer to post unabridged audio, video recordings or unabridged written transcripts. Recordings. Any meeting of a public body that is open to the public shall be open to being photographed, broadcast, webcast, or otherwise recorded and or transmitted by audio or video means. The agency or public body itself is not obligated to record its meetings unless one of its members is participating remotely under extraordinary circumstances. An agency may establish reasonable rules to limit disruption and interference, and we have model rules on the Open Government website, on the Committee on Open Government website. So if you're interested in establishing rules of conduct for people that wish to record or photograph your meetings, we have sample rules on our website that you might want to model yours after. Just as a reminder, anyone who wants to come in and record and photograph, broadcast, webcast, whatever they want to do, they don't need the board's permission. They don't need to give you prior notice. As long as they're not being disruptive, they are free to record, photograph, broadcast, webcast. Executive session. Executive session is defined in section 1023 of the Open Meetings Law as a portion of an open meeting that is not open to the public. It is not prior to or separate from an open meeting. In order to enter into executive session, a motion must be made and voted upon during an open meeting, and the motion must be specific enough to reflect to the public and to the rest of your board that you know you're going into executive session for a proper purpose. Up on the screen right now, which I'll point out, take this opportunity to point out, is I have PowerPoint versions of a similar version of these slides. Actually, the PowerPoint that the PDF copy of my PowerPoint that is available on the opengovernment.ny.gov website actually contains a little bit more detail about video conferencing. So if you go to opengovernment.ny.gov, scroll down a bit, you're going to see a section called Training, Recordings, and Material. Click on that link, you will find my slides. So don't feel like you have to take pictures or notes or anything. This information is easily accessible on our website. So up on the screen, you see the reasons a public body can enter into executive session. If you don't see it on this list, that means that it is not a proper, there is no authorization for entering into executive session. We can talk a couple of most commonly asserted grounds for entering into executive session. For example, discussions regarding proposed, pending, or current litigation, if the library is being sued, or if the library is suing another entity, if there's a notice of claim against the library. Those are situations where the Board of Trustees can enter into executive session to discuss proposed, pending, or current litigation. What this does not mean is a public body is not authorized to enter into executive session to discuss matters which may lead to litigation, because all matters have the potential to lead to litigation. Anytime any public body makes a decision, there's the potential for litigation. So that's not what this is intended to cover. This is intended to allow a public body to actually discuss litigation strategy when they are actually being sued or they are actually suing someone else. Collective bargaining negotiations under the Taylor Law can occur in executive session. I always tell people, I think it's on my next slide, don't use personnel. Do not say you're entering into executive session to discuss personnel matters. It is not sufficient to comply with law to use that word. We see it all the time, no matter how long I've been doing this training and my predecessors have been doing this training, asking people not to use the word personnel in their motions. We still see it all the time. I know it's a shorthand, but it's not a great shorthand because it doesn't really reflect to the public that you know you're going into executive session for a proper purpose. What the language of the statute actually is you're entering into executive session to discuss the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. Am I suggesting that you mimic this statutory language? Not at all. In fact, I would discourage you from just mimicking the statutory language. What I would recommend that you do is think about what you plan to discuss. Look to see whether it fits within the statutory language. Let's say, for example, you want to hire a new library director, and you're going to be reviewing resumes that people have submitted to apply for the position of library director. Well, what you would be planning to do, the motion that you could enter into, the language that you could use to discuss these resumes, is that we move to enter into executive session to discuss the employment history of the applicants that have applied to fill the position of library director. We plan to have discussions relating to the appointment or employment of an applicant to fill the position of library director. Again, you just want to be specific enough, use real language, everyday language, and be specific enough to reflect to the public that you are going in to executive session for a proper purpose. You don't need to identify the names of the candidates. You don't need to use so much detail that you're defeating the purpose of the executive session, but you do want to be specific. The courts have weighed in on this numerous times. Just going back a slide, because again, the only other one that comes up with any type of regularity, I would say, is you can go into executive session to discuss the proposed acquisition, sale, or lease of real property or securities, or sale of exchange of securities, but only when publicity would substantially affect the value thereof. For example, if you as a library are considering purchasing a new building, property, and there's property, a building on the market, and you want, as a public body, want to discuss how much you are willing to offer for that property, that would be a conversation that you could likely have in executive session, because you don't want everyone to know what your high limit is. You don't want everyone to know how high you're willing to go in terms of an offer, because that would put the library in a weakened bargaining position, and that ultimately affects everyone. So that is a proper purpose for entering into executive session. I'm going to talk about public participation a little bit. It's not required. There's nothing in the open meetings law. Well, okay, let me backtrack. Up until about a year ago, the open meetings law was completely silent with regard to public participation. It is no longer completely silent, but it is still not required by statute to offer the public an opportunity to comment or participate in the meetings of the public body. If your board of trustees chooses to allow for a time for a public comment period, you can establish reasonable rules governing that conduct, such as time limits. As long as those rules that you establish are implemented fairly and consistently. And I'll just point out here that hearings are not the same as meetings. Sometimes there are things like budget hearings that are required by statute for an entity to have. And that's where there's an expectation under state law that the public will be heard regarding a topic. So hearings are not the same as meetings. Meetings are where the only people that have a right to speak and participate are the people that have been appointed or elected to serve on the public body. If a hearing is required by statute, it may have to comply with both the open meetings law, because the hearing is being hosted by the public body. But in addition to having to comply with the open meetings law, there are other statutes where there's an expectation of public participation. So we talked about executive session. So now I'm just going to mention exemptions. There are two mechanisms for meeting behind closed doors as a public body. The first is executive session, where that's a portion of an open meeting, meaning you first have to have an open meeting. And then once you have the open meeting, you can make a motion to go into executive session. And that motion has to occur in open session. The vote needs to occur in open session. And then the public body can enter into executive session behind closed doors. So that's one mechanism. The second mechanism is where there's an exemption from the open meetings law. And if an exemption applies, the open meetings law does not apply at all. It's as if the open meetings law does not exist. The three exemptions are judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and zoning boards of appeals. The second is deliberations of political committees, conferences, and caucuses. And the third is discussions relating to any matter made confidential by federal or state law. It's my belief, and people can correct me if I'm wrong, is that the first two bullet points here, the first two items come up very infrequently, if ever, in the library setting. But where the third bullet often comes up is when a public body such as a board of library trustees needs to request and receive legal advice from their legal representation, from their attorney. Conversations between a board and their legal representation for the purpose of requesting and receiving legal advice is covered by the attorney-client privilege. The attorney-client privilege is codified in New York State statute. There is a state law that creates the attorney-client privilege. So therefore, a conversation that's covered by the attorney-client privilege is a matter made confidential by state law. There are other scenarios that come up in other settings. I think, for example, that there are confidentiality provisions relating to library users, personal identifying information relating to library users. That might be another scenario where the board needs to have a conversation relating to a particular library user and that conversation is required to be made confidential by federal or state law. So I'm getting towards the end of what I wanted. That's sort of the overview, but we haven't gotten to video conferencing yet. So I want to go back to the beginning. Sorry. I don't want to take up too much of your time. I want to make sure that we have plenty of time for questions and answers. So a lot of information up here. Some of it is a little bit dated. I apologize. The only PowerPoint that I was able to pull up on my network for some reason is a little bit dated. So I suppose in this setting, just sort of listen to my voice as opposed to worrying too much about the exact content of what you see on this particular screen because it's a little bit dated. In fact, you'll see it's from, again, about a year ago. Oh, this is not even a screen I want. Sorry about this. Here it says, this is where I want. The slide that you're looking at before was only in effect last year prior to the expiration of the declared disaster emergency, the COVID state of emergency. Now that is expired, it expired in September of 2022. So there's no authorization at this point for public bodies to have completely remote meetings. At this point, you need to either revert to the way you held your meetings pre-COVID, or you can take advantage of this new provision that was added in the spring of 2022 during the, as part of the 2022 to 2023 budget bill that expanded the use of video conferencing, but only under extraordinary circumstances. So Chapter 56 of the laws of 2022 is the statute that amended the open meetings law to add a new section 103-A. And as a threshold matter, it's our understanding that this new amendment was not meant to change or curtail what has always been required and allowed of public bodies when complying with the open meetings law. Public bodies may continue to operate now as they did before the onset of the pandemic in early 2020, when the in-person aspects of the open meetings law were first suspended. In other words, we believe that if a public body was permitted to do it before the pandemic, this law does not change that. It's only intended to expand, in extraordinary circumstances only, the ability of public bodies to meet using remote access technology. I'm going to skip over that. And here, I want to get to my Q&A. Sorry. Oh, sorry. Let's see. So I'm going to stop sharing this, and now I just need to pull up. So let's hide this. Get rid of this. There we go. So you can see the whole screen. So what I'm going to do is try to briefly go over the main points of the new amendments to the open meetings law relating to video conferencing. And as you'll notice here, sorry, I'm going to go to my homepage. Where I found this Q&A is right on the Committee on Open Government's website. So up on the top of the screen, you'll see here this section called Q&A, Model Resolution and Model Procedures relating to Chapter 56 of the laws of 2022. So in terms of were the public bodies required to comply with these new provisions right away? The answer to that was no. There was a sort of a grace period. It was actually a much longer grace period than the legislature actually intended. The original grace period was 60 days, but in essence, it didn't really go into effect. People weren't really required to worry about the new video conferencing provisions until the state of emergency expired in September of 2022. So what Chapter 56 was, again, it expanded the use of video conferencing, and it allowed public bodies to allow its members to attend from private locations that are not open to the public, but only under extraordinary circumstances. So each public body that wishes to allow for remote attendance by its members at locations that do not allow for in-person physical attendance by the public is required to adopt a local law, but that only applies to governing bodies of counties, cities, towns, and villages, or adopt a resolution, which would be a library board of trustees is required to adopt a resolution. But first, in order to adopt the resolution, it must first have a public hearing. So a library board of trustees, if it wants to take advantage of this new provision, must adopt a resolution preceded by a public hearing authorizing the remote attendance, and must establish written procedures setting forth what they deem to be extraordinary circumstances. The open meetings law includes a non-exhaustive list of those circumstances, including disability, illness, caregiving responsibility, or any other significant or unexpected factor or event which precludes the member's physical attendance at such meeting. I'm going to switch things up a little bit because I think I have a better way of going over this with you guys. As I mentioned, I was having trouble pulling up from my home network what I wanted. So I'm going to there we go. This is in my mind, a much easier way. I apologize. Kind of the formatting is a little funny because it's a PDF instead of a PowerPoint, but I think it'll be easier. It's a little plainer language. So there are two ways to use video conferencing technology now. One is the way that has existed for several years pre-pandemic, where you could connect multiple physical locations that are open to in-person public attendance. For example, the Committee on Open Government is an 11-member body, and the people that serve on the committee are from all over the state of New York. When we have our meetings, we establish public locations in Buffalo, Albany, and New York City. When we send out our notices, we include the addresses for all three of the physical locations in Buffalo, Albany, and New York City, and include a statement that the public is welcome to attend from any location. So some of our members attend from those locations. The public can attend at those locations. They're all open locations that are noticed to the public and where the public are allowed to attend. This ability to use video conferencing has been in place for several years now. The second mechanism for using video conferencing is the new provision that was added by Chapter 56. And that's where you're allowing a member of a public body to participate from a private location through video conferencing, but only under extraordinary circumstances. Public bodies using the first type of video conferencing, where you're connecting multiple physical locations that are open to the public, the new Section 103A of the Open Meetings Law does not apply. The new language of the statute says the public body may, in its discretion, use video conferencing to conduct its meetings, provided that a minimum number of members are present to fulfill the public body's quorum requirements in the same physical location or locations where the public can attend. So if you remember back towards the beginning of the program, I talked to you about how to meet a quorum, and I told you that the members of the public body only count towards a quorum if they are attending and participating from a location that is open to the public. If they're sitting at home or any other private location that has not been noticed to the public, that is not open to the public, they cannot count towards a quorum. The law states that the public body must establish written procedures governing member and public attendance consistent with the section, and the written procedures have to be conspicuously posted on the public website of the public body. The law requires, the legislature here showed a clear intent and preference for having in-person meetings. Prior to the passage of Chapter 56, the New York State Legislature had public hearings to hear, to get input from the public at large, from members of public bodies, from anyone that had something to say about the use of video conferencing or remote access technology, and how that made open government either better or worse during the pandemic. So the legislature had the hearing, they listened to what people said, and we must presume they took that information and used it to form these new amendments. And by doing so, they have showed a clear preference for in-person meetings. They do not want to let public bodies to have fully remote meetings. You can't have a fully remote meeting anymore because you can't have all members attending from closed private locations. There would be no way to meet your quorum requirement. You have to have a majority of your members present at a physical location or locations that are open to the public. So here, again, the language states that the members must be physically present unless they're unable to be physically present due to extraordinary circumstances. And again, the Open Meetings Law defines extraordinary circumstances to include disability, illness, caregiving responsibility, or any other significant or unexpected factor or event which precludes the member's physical attendance at the meeting. Except in the case of executive session, the members of the body must be heard, seen, and identified while the meeting is being conducted. That means cameras on. During the pandemic, sometimes we'd hear from the public or even get questions from the public bodies themselves, wondering during the pandemic when they were using Zoom or WebEx or whatever the case may be, do the members of the public have to have their cameras on? And during the pandemic, the answer was no, because the executive orders and the statutes that authorize remote attendance only said that the members had to be heard. Did not require that the members be seen. This provision requires that members be seen and identified. So cameras on, and people who are attending remotely should be typing their full names in on the screen, so that at the bottom of the screen it shows a full name. The minutes of the meetings involving extraordinary circumstances must include which, if any, members participated remotely, and must be available pursuant to the regular obligations under the Open Meetings Law. If this extraordinary circumstances video conferencing is used to conduct a meeting, the public notice of the meeting must inform the public that video conferencing will be used where the public can view or participate in the meetings, where required documents and records will be posted or available, and must identify the physical location for the meeting where the public can attend. The public body shall provide that each meeting conducted using extraordinary circumstances video conferencing shall be recorded and the recordings must be posted or linked on the public website of the public body within 5 business days following the meeting and shall remain so available for a minimum of 5 years thereafter. Recordings must be transcribed upon request. During the pandemic, if you used remote access technology, the executive orders and the laws said later transcribed. Here, it just says transcribed upon request. I know a couple of entities have raised concerns about bandwidth issues for having to post their the recordings of their meetings on their websites. I can give you one recommendation that the Committee on Open Government itself has taken advantage of is we use YouTube. Our website contains a link to YouTube. So if you go to the section, where we have information about our meetings, we have a link to meeting recordings that brings you to a YouTube page, and YouTube stores our meeting recordings for us. Extraordinary circumstances video conferencing is used to conduct a meeting. The public body shall provide the opportunity for members of the public to view the meeting via video. So if you have one of your members participating via video, extraordinary circumstances video conferencing, you have to make that option available to the public as well. And if you offer a public comment period or a privilege of the floor or whatever you call it, if you allow members of the public to participate in your proceedings, if they attend the meeting in person, you have to also allow them to participate in the public comment period via video conferencing. So here, that's a difference between what was required during the pandemic. If you allow for public comment in person, you have to allow for public comment via video conferencing. The same rules that apply to people that are attending in person have to apply to the people attending via video conferencing. Any local public body, any municipality electing to utilize video conferencing to conduct its meetings has to maintain an official website, because there's no way to comply with Section 103A without having a website. The in-person participation requirements can be suspended during a state disaster emergency declared by the governor or a local state of emergency proclaimed by the chief executive of a county, city, village, or town, if the public body determines that the circumstances necessitating the emergency declaration would affect or impair the ability of the public body to hold an in-person meeting. So in short, if you're having, worst case scenario, there's another significant uptick in COVID outbreaks, and either the governor declares a state of emergency, or the uptick is confined to one small area, perhaps. Maybe your county executive or county board of supervisor declares a local state of emergency. In those circumstances, if the state of emergency would affect or impair the ability of your public body to hold an in-person meeting, this provision allows the in-person requirement to be suspended. There are states of emergency that are in effect that do not affect or impair the ability of the public body to hold an in-person meeting. For example, right now the governor has in place, I believe still has in place, state of emergency relating to polio, state of emergency relating to monkeypox. Those states of emergency do not affect or impair the ability of your public body to hold an in-person meeting, unless for some reason your municipality has an unfortunate polio or monkeypox outbreak. No later than January of next year, the Committee on Open Government is required to issue a report to the governor and the legislature concerning the implementation of these amendments. So if you have feedback regarding these amendments, we welcome them. We ask you that, send us an email, send us a letter, whichever you prefer, letting us know what you think the benefits of this amendment are, what maybe the drawbacks of the amendment are. Please let us know. One, I think, final point is that if you're using video conferencing technology, you must make sure that it is that the technology is consistent with the 1990 Federal Americans with Disabilities Act and the corresponding guidelines. Our attorneys in our office are not authorized by law to provide legal advice regarding the ADA. So my recommendation would be to consult your own legal counsel regarding compliance with the ADA. So here, I'm going to switch off from screen sharing. I'm going to start my video up, and I'm going to go back to see Rebecca and see how we want to do some questions and answers.
Kirsten, thank you so much. I know it was a lot of information for folks in the audience, but again, you're going to get a copy of the slides in the chat box. I hope you noticed that I put the document that outlined the whole video conferencing Q&A. It's a lot to take in, right? And I know a lot of you are disappointed. A lot of people felt like the pandemic set a precedent. And of course, we would continue online meeting. And I can tell from some of the questions that have already come in tonight that some of you might not have gotten the memo on the fact that the law has changed in respect to this. So we know there's a lot of questions related to video conferencing, along with a number of other things that have come in so far, Kirsten. Before we go into some of the questions that came in, I wanted to ask you questions that came in before the webinar that we didn't quite get to, or that I think might bear repeating in some cases. And so going back to kind of early on, you noted that anytime a quorum of the board is together to discuss quote unquote public business is when we're triggering open meetings law. And we got a lot of questions before the webinar about what constitutes public business.
I think there's no statutory definition of it, but it's going to relate to anything, probably anything that involves your library for certain, whether it's, spending money, any sort of personnel decisions, financial decisions, anything that affects your library is going to be public business. It's going to be very broad. Again, it's certainly having a social gathering where you mentioned, doesn't the library look beautiful? It's not enough going to be to trigger it. But anytime you're thinking about, if you get into a conversation regarding finances for the library, personnel decisions for the library, facility changes, upgrades, things of that nature, it's incredibly broad. So if the reason you're having this conversation with other members of the board is because you are a member of the board of trustees, it's probably a discussion relating to public business.
Great. Thanks for, I don't want to say paint it with a broad brush, but just kind of confirm that it's a broad definition of what qualifies as public business, right?
Exactly.
Cool. So I'm going to go back to the video conferencing one, because I bet you've been talking about that a lot over the past few months.
Yeah, it can get a little confusing. The language of the statute was a lot to wade through.
So one of the questions that's come up several times for us is, the Q&A you supplied, which again has been linked in the chat box for everyone to click on and read that language themselves when they really can take it in. This definition of extraordinary circumstances. We've had two questions come up over and over again. So the first one is, can a local board, a library board, define extraordinary circumstances that might go beyond the specific text of the amendment in Chapter 56? Could they add in a snowstorm to that list of things that would be an extraordinary circumstance?
They can certainly they can expand the definition, but I do want people to keep in mind that any expansion of the definition could possibly be subject to court review. And you want to make sure that, any expansion of the definition is going to seem reasonable to the courts. And two, again, keep in mind that you still need to have a quorum show up in person. So like, for example, you use snowstorm. We've gotten that question a lot. Is that an extraordinary circumstances? Well, yeah, it probably is. The way we think of extraordinary circumstances, yes, a snowstorm is, but if there's a snowstorm, is it really fair to say, okay, well, the first person that asks for extraordinary circumstances gets it and everyone else has to trudge through the snowstorm? No, the better option is to cancel the meeting and reschedule during nice weather, because it's, you don't want to be having to choose which people have to, drive through the bad weather. And people that do like to show up in person for their meetings, they should be given that opportunity and should not have to maybe, face bad weather, just if you're not making everybody face
Right.
bad weather.
I think that's great. I thought it was great that you itemized the state of emergency. It's not like you feel like it's a state of emergency. It's been declared a state of emergency by the state, the county, or the local government.
Exactly. So you as library boards of trustees are not really going to have much say in that. You'll get to take advantage of it if your municipality, if your county declares a state of emergency, and then you may need to take that information and make a determination as to whether it affects or impairs your ability to have a meeting.
Cool. So I think, for everyone online today, in-person meetings are here to stay, but you're welcome to write that letter that was the feedback encouraged before the end of the year to inform the report of the Committee on Open Government of how you feel about the new video conferencing amendments. But Kirsten, thank you for being so clear about the fact that in-person meetings, a quorum in person is absolutely necessary. There's a citation from the law that defines extraordinary circumstances that best practice would have folks just copy and paste into their own resolution if they want.
That's what we did.
Yeah, that's what we did too here. And I know Ron did too, because I modeled mine after his. And I'll just point out that in that Q&A document that was linked in the chat box, not only are there answers to the questions you have, there's also the sample resolution you could have at a public hearing. And I just want to make sure everyone heard the distinction Kirsten mentioned that, usually when you're passing policy at your library board meetings, you're doing so in an open meeting session. But for the purposes of this particular amendment to your procedures and policy, you would need to convene a public hearing. So another link I put into the chat for you is just the basics of how to hold a public hearing, which you can do on the same day as a board meeting, but you do need to, you're mandated to allow the public to comment on that. It's not just, it would be nice to hear from them. They're allowed to speak during that, whether you like it or not. Yeah, cool. So I have one more question for you that I'm going to let Ron and Brian work their magic on the Q&A box here and help you answer some of the other questions that came in here. The issue that I feel like I answer a lot for people is what is sufficient public notice when it comes to maybe notifying media outlets or posting the information? Do you have to do it every single month? Could you do it all at once in the beginning of the year? What would meet the test of providing public notice of our board meetings?
Sure. So I like the idea, if you have, for example, an organizational meeting at the beginning of the year or whatever the case may be, if you have a set schedule at the beginning of the year, do it all at once. You're not required to. It's just 72 hours. If you have a schedule, the minimum amount of notice that you have to give is 72 hours prior to every scheduled meeting, assuming that the meetings have been scheduled at least a week in advance. However, I think many public bodies find it useful to just do the notice all at once, whether it's the beginning of the fiscal year, the beginning of the calendar year, whatever the case may be. Establish your meeting schedule. It doesn't mean that you can't make amendments to that schedule as the year goes on, whether you need to have a special meeting or whether maybe you need to change the date at some point. You're not writing it in stone. You're just making your life easier by establishing that schedule, putting it up on your website, sending it out to your local media representatives, whether it's, it's your closest newspaper coverage. Again, you don't need to purchase a legal notice. You just need to notify the media. It has to be paid media. So for example, it can't be like your local penny saver or something like that. It does have to be a sort of a private news organization of some sort. Usually it's in the local newspaper, and getting it up, for example, on your bulletin board. But if changes come up, for example, if you know that there are going to be a couple of meetings where one of your members wants to use the extraordinary circumstances video conferencing, and that wasn't established at the beginning of the year, you could do that as you go along. But you are going to want to make sure you're providing that 72 hours notice. If somebody gets sick the day of a previously scheduled meeting and wants to video conference, I have to say, technically, you're not going to be able to do it because you're not able to give 72 hours notice that that person is participating. One option to make sure that they can do that if that comes up is to just always have it set up so that there's the possibility of having extraordinary circumstances video conferencing. For example, your meeting notice could say something along the lines of, we may have members participating using extraordinary circumstances video conferencing. And regardless of whether we do or do not, here's where you, the public, can participate via a video conference. Here's the link that you will be using. But changing the notice on short notice isn't technically compliant with the open meetings law.
I guess it's a good time to remind everyone that at your organizational meeting, you should be confirming your newspaper of record. So it's very clear the board's intent of where you would send your meeting notices. As Kirsten noted, it needs to be a traditional, perhaps a newspaper, which I know in some communities are in short supply.
Yeah.
But you should be very transparent about which newspaper people could expect to find that notice in. Cool. So I'm about to turn things over to Brian and Ron to moderate the questions that came in so far. I just want to say that I'm going to stay online though, because I see a couple of questions have come in over time that are specific to library charters and bylaws, which we can't expect Kirsten to know the ins and outs of. So Kirsten, I'm your lifeline, and anything that comes in that touches on that stuff.
Thank you. I appreciate it.
All right.
All right, I'm going to ask the first question that came in our Q&A, Kristen. And first off, that was really fantastic information all around. So thank you so much for that one. And also for one of the earlier questions that Rebecca asked, I happen to really like posting all of my meeting dates at the beginning of the year, because then if trustees are like, we might not be able to make it, I can say, well, we already told the public we were going to have a meeting, so you better show up. But one of the first questions that we have that has popped up is, so we have a library and they meet with their director to discuss their performance evaluation. May the board go into executive session for that topic?
The performance evaluation of the director?
Yeah.
Yes, because it would be a discussion relating to the employment history of a particular person.
And I really liked how you had mentioned earlier on in the presentation that use that line from the allowances of executive session, but make it clearer and more understandable of exactly what the reason is that you're going in there. So that's really great.
Good.
All right, Kirsten, the next question that we have coming through, both you and Rebecca actually answered this question in both your presentations, but it keeps popping up in the chat as well as the Q&A. So I just want to make sure that we get it addressed. One is just, does open meetings law apply to committees? And so several of our participants did a good job of listing the very specific committees that it seems like that they serve on. So the personnel committee, the building committee, the finance committee. So does OML apply to those committees? And I'm going to throw one more possible body in there to see if it applies to OML applies to it, and that is the Friends of the Library. So a separate 501c3 does not operate under the arm of the library's governance, but operates under its own 501c3. Okay. So for those board committees, as well as the separate 501c3 Friends of the Library, does OML apply?
So the first part of your question, it's going to depend on whether you're a public library or an association or free library. Government, I should say government funded, but I think is it the reference in the statute, is it school district libraries or is it just public library? But if it's a public library funded by taxpayer dollars, like there's a separate line item on your local taxes for the library. Generally, if it's a public library, then the board of trustees for the public library meets the definition of the open meetings law. Because it meets the definition of public body under the open meetings law, all of its meetings and all of the meetings of its committees and subcommittees also must comply with the open meetings law. However, if you are an association or free library, your board of trustees is not a public body that is as the open meetings law defines it, but New York State education law says, too bad, you're subject to the open meetings law anyway. But just your board of trustees, not your committees. Again, to throw one more caveat, unless you're a city of population of 1 million or more. So for most, non-New York City municipalities, you just your board of trustees association and free library boards of trustees are subject to the open meetings law. Committees and subcommittees of those association free are not required to comply with the open meetings law. Committees and subcommittees of public libraries are required to comply.
And I'll just jump in here and say that association libraries, if your name of your library has the word free in it, it doesn't necessarily mean you're an association library. So you need to understand your charter and make sure you're actually an association library if free is in your name. The free doesn't actually qualify as a legal classification anymore. So it's association libraries versus the other three types, which are municipal, special district, and school district public libraries.
Thank you, Rebecca. That always confused. I just actually had to look up something about libraries the other day too. Someone had asked a question. And I always have to, I go to the public library's website and or the library's website, and I try to find like, their bylaws or something that tries to help me figure it out.
And the bylaws issue came up during the Q&A period too, Brian and Ron. I hope you don't mind me, because I just answered that one on my own in there. But folks were asking about, calculating quorum, and would it be based on the number in their bylaws? And just a reminder to everyone, the number of trustees for libraries is set in your charter that's issued from the state. So that is of a higher legal standing than your bylaws. So you want to make sure your bylaws and charter match. And if your charter has a range in it, maybe it says 9 to 11 trustees, your bylaws have to have a specific number so that you can calculate your quorum based on that. So just make sure you're matching up those two documents and your charter takes precedent.
All right, I have a softball one for you, Kristen, but I'm going to throw a little bit of a curve in there. So the question that came in is a quorum required to open or close a meeting? And then a follow-up question that was later on in the Q&A was, what happens if trustees have to leave early and then your number drops below quorum? So you started the meeting with quorum, but then they had left, and do you need a quorum to open and close a meeting?
You're going to need a quorum to open the meeting because you can't conduct public business unless you have a quorum present. So you are going to need a quorum to open the meeting. In terms of adjourning, the open meetings law doesn't really use those terms. Like, they don't talk about the motion to open the meeting, the motion to adjourn the meeting. That it's those procedural type questions are not really addressed by the open meetings law. But my thought is once you don't have a quorum present anymore, I don't really see any point in engaging in substantial deliberations, because you're not supposed to be conducting public business. You don't have the authority to conduct public business unless you have a quorum present. Certainly, if someone just gets up and leaves, you can adjourn the meeting. That's not really anything substantial. You don't have to stay there all night and wait for that person to come back. But yes, you can adjourn the meeting without having to have the approval of the entire board, or a quorum of the board. But you do need a quorum in order to conduct public business.
That sounds like a great answer. Thanks, Kristen.
Kristen, I've got a question that builds upon just a little bit what Ron asked about, and it kind of takes us back down memory lane. We talked a little bit about this last season during Trustee Handbook Book Club, but how do you handle issues that must be discussed between board meetings? Seems like there's a limit on the types of conversations that can take place between one board meeting to the next board meeting, or one committee meeting to the next committee meeting. It'd be interesting to hear what your offices have to say about this matter.
I think what it is you just want to be careful that you're reflecting to the public, you're being transparent about how things are operating. I don't see any reason why you can't get administrative things done. Sometimes, people are like, wait a minute, do I have to have a meeting to even schedule a meeting? Well, no, if you guys can all come to a consent, maybe you do need to reschedule a meeting, and you need to come to a consensus as to what the date that works best for a majority of the board members. Do I think you need to vote on that? No. Those are the types of administrative type things that I see no reason why you can't discuss those things during between meetings, like, for example, via email. Other things, email is a wonderful tool, and I would never discourage any public. We at the Committee on Open Government use it all the time. At the end of the year, we're required to prepare our annual report to the governor and the legislature. And we try to we, the staff, we put together a draft, we send it out via email, and we ask everybody to email us back their comments. Now, we take advantage of the meeting to go through the comments and, make sure if there are any substantive changes, we've got to get approval by a quorum of the Committee on Open Government to make any substantial changes. But it doesn't mean that we're not opening up that conversation to that feedback. Let's get everyone's, the wheels turning in everyone's mind. Let's get everybody thinking about this so that once we get to the meeting, we know perhaps what we want to say and what our position is, and we feel educated about the issue. I think those are the types of conversations that are useful to have between meetings, so to speak. But what, in my view, you don't want to do is engage in such substantial deliberations that when you get to the meeting, all you're doing is voting. Because we get, a lot of, complaints, I guess, for lack of a better word, from the public saying, not necessarily, not particularly about libraries, but, their towns, their villages, their cities, whatever the case may be, they get, very frustrated with, I guess, like, for example, consent agendas, where it's not just simple administrative things that are on the consent agenda, but bigger ticket issues, issues that the public expected the board would engage in deliberations regarding, that they would want to have it discuss in public, that different board members would have different opinions about these issues, and that it wouldn't just get plopped onto a consent agenda and voted on at the end of the meeting. That's what I would certainly discourage board members from doing. Don't get to that level. Sometimes I've heard, well, our president of our board likes everything to be unanimous and likes to have everything settled before we even get to the meeting. I think that's a terrible idea. The public wants to know, like, if the public has a concern, I think it's helpful if they're aware that maybe one of the other board members had that same concern and the concern was addressed or at least taken into consideration by the other board members when making the decision. So that's my thought about conversations between meetings.
And also in the trustee handbook, I may misquote this, Rebecca, but I think it says disagreement or discussion, deliberation, and even disagreement are expected on library boards. So have those conversations because that's the whole point of getting together and talking about all those things.
Right.
That was great, Kristen. This one is an interesting one. So you've answered the Zoom video conferencing questions quite a bit. This is a little bit of a different spin where one of the participants, their town attorney, has interpreted the law that Governor Hochul had passed a little bit differently, and it says if a board member is participating via Zoom, their presence counts towards quorum, but they cannot vote. What's your take on this? And I think you had answered this question. However, I think it brings up a broader question for if a library is getting advice on open meetings law from, let's say, a town attorney or their own attorney, and they come here tonight and they see like, oh, I guess that isn't the right information. What would be your process for answering those types of questions that come in as well?
Well, I think if I was actually talking to the attorney, I would ask them to point to the statutory language that they believe that they're relying on, because there's nothing in the open meetings law that says, for example, that people participating towards via Zoom count towards a quorum but cannot vote. In fact, it's the opposite. They don't count towards a quorum, but if a quorum is otherwise met, they can fully participate and vote. I mean, there's the two types of video conferencing where, if people could be participating either from a private location. If that's the case, they don't count towards the quorum. If you've got somebody attending from a secondary open location, sometimes it's just because they're on vacation in Florida, but they're willing to open, like maybe go to the public library in Florida and use one of their conference rooms and include that contact information in the meeting notice. If that's the case, if the location where if the secondary location, so to speak, is open to the public, yes, they do count towards a quorum, and yes, they can vote. The only option that I can think of that this particular attorney might, I don't know. I can't think of any situation where somebody would count towards a quorum but can't vote. I can't think of a single situation where that would be the case. So, but what I would encourage, if someone is experiencing a conflict between what I'm saying today and what they've been advised by their attorney, maybe reach out to the attorney first, give them an opportunity to weigh in. And I'd love it to be a conversation that involves all three of us. I always hate to, be in a situation where I feel like I'm giving legal advice behind another attorney's back. I want to be open about the conversation. So it's helpful if you're getting frustrated by the attorney and they're not really willing to engage in the conversation, you're still welcome to reach out to us. I'm going to answer your question anyway. But as I said, sometimes it's nice to have that 3-person conversation so that all the parties know where we're all coming from.
That was such a kind and diplomatic way to answer it, because I would have been like, I'm going to email Kristen. I'll show you. So thank you so much. That was really great.
And we've got lots of great questions. I wish we had like another hour to go through all of these. So the next question that comes up is specifically about executive sessions. So how do you handle an executive session where you're going in to talk about 2 completely separate topics? And then a second part to that question is, how do you handle the phrasing or the resolution to go into that executive session so that you are not highlighting the very specific essence of an employee, particularly if you're talking about personnel? We know we're not supposed to say we're just going in to talk about personnel matters, but what's the language that we should use if we're talking about 2 topics? And then also, how do we be mindful in our language so that we're not highlighting the talking about a single personnel matter or a single person?
Yeah, and the first part's probably fairly easy enough. It's just use and. Sorry, I don't mean to keep knocking my laptop here. Just use the and. For example, I make a motion to enter into executive session to discuss the John Doe litigation and to discuss matters, the employment history. Let me try to be a little, maybe you might say possible disciplinary actions involving a particular employee. Again, you don't need to identify the employee by name or by title. What I just try to encourage people to do is to look at that. It's this very long block of language, pluck out the parts of it that pertain to your situation. Am I discussing the employment history of a group of individuals because they've applied for a job? Try to say that, because it's probably not a secret or private that a position is open, especially if it's civil service. That the fact that people might be applying for the position, that a position is open is not the secret part. The part that you probably want to try to keep private or confidential in order to protect the privacy of the applicants is the name or anything identifying details of the applicant. So if you could say, yes, we've got an opening for assistant library director, we're entering into executive session. I moved to enter into executive session to discuss the resumes we've received for the posting of assistant library director, and to discuss the John Doe litigation. So really, it's in terms of multiple reasons for entering into executive session, you should include them all. And just use and. But the other is in terms of, it's trying to be specific enough to make sure that you're reflecting that you're going in for a proper purpose, but not being so specific that you defeat the purpose of the executive session.
Ron, I think I don't have enough time to type your answer, so I'm just
That's
going to go.
okay.
Yeah,
Perfect.
Kristen, we're watching the time. We like to respect everyone's time, especially yours. So we just have one more question, then we're going to wrap things up. A bunch of questions came in about the number of folks on a committee that triggers in a public library setting that need to follow open meetings law. My understanding is that it's 2 or more trustees. Is that correct?
Correct. Yeah.
Yeah. So it's not a quorum of the board on the committee. It's 2 or more members of the board on a committee that qualifies it under open meetings law.
You got it exactly right.
Okay, cool. So we know we didn't get to all your questions. You folks sent in a lot of questions. So just a reminder that we always do what we call the after party recording to tackle the rest of those questions that came in that we might not have gotten to this evening. I'll also point out, and we'll put the link right in the chat box, that the Committee on Open Government, Kristen herself has authored many advisory opinions, and they're all alphabetically arranged to make our library hearts sing. So if you've got questions about public notice, executive session, all the topics that we were able to cover here today, many of them have advisory opinions that have been already posted on this website that I'm about to post into the chat box for you, or you can go and look those up. And then if you're not finding what you thought you would, that's when you could trigger a call or an email to Kristen's office. I'll say that the video conferencing advisory opinions might not have caught up with the amendments just yet. So that's an area just to always be aware of, the posting of public information that's going to be discussed at your meetings. And the issues related to video conferencing are relatively new, so not as many advisory opinions on those topics. So Kristen, thank you very much for your time this evening. I think that a lot of the questions we got showed that just the basics sometimes are still needed out there for the trustees that are volunteering their time and energy to our public libraries across the state. So thank you very much. I'll point out to everyone else on the call that this is our first session of the year, and that we have a full schedule for you this year. So next one coming back up is in April. You're going to see Jerry and I again. So if you're missing Jerry, don't worry, he's coming back next month. But we are switching things up this year. You're going to hear more from other folks than just myself and Jerry. We think it's important to hear from experts in their field like Kristen. So we thank everyone for being here tonight. And as always, thank you for volunteering at your local library. Libraries work because you take the time to stand up and make things better for your neighbors. So thank you so much, not only for your service to your library, but about learning about the laws that impact our libraries and how to build trust in our community. So thank you very much, and we'll see you next time.
Thank you.
Thank you so much, Kristen, and everybody else. Take care.